Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 150. Well, this feels like a bit of a milestone. Partly to mark the occasion, but also partly because we've been thinking of doing this for a while. We've done a bit of a revamp on the podcast. It's now available in a whole lot more places. We've revamped the music. Out goes Vivaldi. It's quite difficult choosing music for this series, you know. You really don't know what you're looking for until you find it, which is all suitably vague. Anyway, I hope you like the new music. We haven't changed the format, i.e. the review of 3 recent cases. This seems to fill a definite gap in the market. And from the comments we get, the approach does seem to strike a chord with many people. We will, of course, continue to do guest episodes too. And speaking personally, I always found them very interesting because, again, interviewing people about recent cases or about their job or whatever, it's a wholly different skill set from presenting a short piece on the podcast about a recent case. Anyway, if you have any questions or comments about the podcast and its relaunch, please let me know. If you've got any feedback, please let me know. Basically, someone talk to me. Anyway, we have, of course, 3 cases. We have, this time round, Antutsits and others, and DJ Houghton Catching Services Limited and others. It's on liability for directors, personal liability for directors for breach of contract by their company. I think it's a pretty important case, I have to say. If you're a director of a company or advising directors of companies, you should certainly pay attention to this. Secondly, Ahmed and Cardinal Hume, which looks at disability discrimination and whether an individual has been subject to harassment by the employer. Finally, a case in the European Court, Bosworth and Arcadia, which looks at our old friend, territorial jurisdiction, and comes to, maybe a slightly surprising conclusion. Finally, as a special 150th birthday present, I got a recommendation for a podcast series for you. And, by the way, it has excellent theme music, I think. Anyway, Ahmed, let's start with Ahmed and the Cardinal Hume Academies. This is a case to do with disability discrimination and the circumstances in which an employer could, or should, be found to be guilty of unlawful harassment and direct discrimination. Let's start with the facts. The claimant has dyspraxia, which means he has difficulties with reading, comprehension and handwriting. Indeed, he is apparently unable to write for more than a few minutes due to pain in his hands. He whatever his first job was, he was retraining as a teacher through the Teach First scheme, which allows people with no previous experience of teaching to move into teaching. He went into the process in 2016, making those running the course fully aware of his disability and its effect. He was then given a placement with the Cardinal Hume School in June 2016, I assumed start in the September term. Anyway, the head teacher at the school became aware of the claimant's state of health and had a number of concerns about his ability to cope with the proposed role. The chief executive of the school and the head teacher met with the claimant in September 2016. There was a disputed account of what went on at the meeting, but the claimant asserted that the 2 representatives of the school were insensitive. They were very negative to him about his health, he said, and in particular on the handwriting issue. The head teacher, when subsequently giving evidence at the tribunal stage, accepted he had been sceptical of the claimant's ability to undertake the job, given the handwriting difficulties. There was then a follow-up meeting with the candidate, which the language appears to have been somewhat unclear, but he was effectively suspended or put on garden leave. The teachers were rather unclear with the claimant, pending a further investigation into his ability to do the job. The CEO of the school told the claimant, he expressed a view that it might be more sensible for the claimant to be part of the School Direct scheme, which apparently is a less prestigious scheme because individuals don't have sole responsibility for their classes. The claimant disagreed with this, submitted a formal grievance, and then resigned and claimed constructive dismissal. He asserted the head teacher had acted in a discriminatory and harassing manner towards him regarding his dyspraxia and related handwriting difficulties, and as a result he'd been directly discriminated against, or he had been harassed. He said the decision to suspend him, for example, was entirely unnecessary. He brought a tribunal claim. I'll come back to the legal basis for that claim in a second. But it was accepted by the tribunal and by the employer that the claimant was disabled by reason of difficulty with handwriting, including hand pain. Well, the claimant brought a tribunal claim, as I say, and claimed he was directly discriminated against, contrary to Section 13 of the Equality Act. And that's where a person, quote, a person A discriminates against another person B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others, unquote. For the purpose of Section 13, if you're looking at less favourable treatment, then there must, in comparison with any other case, there must be no material difference between the cases. So the comparator and the other individual, there must be no material difference. And specifically, the legislation says, if the comparison is being made for the purpose of disability discrimination, the comparator's abilities should be the same or have no material difference to those of the claimant. That's going to be important. In relation to harassment, let's do the other bit of the legal case. In relation to harassment, Section 26 of the Equality Act sets out the definition and provides, quote, a person, A, harasses another person, B, if A engages in unwanted conduct related to a relevant protected characteristic and the conduct has the purpose or effect of violating B's dignity, creating an intimidating, etc. environment, etc., etc. So conduct has the purpose or effect of violating the dignity and the conduct is unwanted. Crucially, 26(4) of the Equality Act says that in deciding if conduct has the effect of creating that impact, not when it's the intention, but if it has the effect of creating that impact, the following, quote, must be taken into account, unquote. And this includes the perception of B, the alleged victim, and the other circumstances of the case, and whether it is reasonable for the conduct to have that effect. Here, the Employment Tribunal hearing the claim dismissed it. They said that the questioning, etc., at the meeting on the 7th September was certainly unwanted, but it was not reasonable for the claimant to view them as harassment. The head teacher was profoundly concerned about whether a new and inexperienced teacher would be able to undertake this responsibility if he couldn't write for more than a few minutes. The head teacher had a responsibility for the education of the pupils, as well as for the welfare of the teachers. And on that basis, the tribunal said that the questioning and approach adopted in the meeting did not amount to harassment. While the suspension was, in my terms, messy, the majority of the tribunal accepted, again for the same reason, that it did not amount to harassment. A minority of the tribunal agreed. In relation to direct discrimination, however, the tribunal decided there were no facts from which it could find that his suspension or proposed move from Teach First to the Schools Direct programme was because of his disability, and so his claim failed. Claimant appealed to the EAT on the grounds that, in relation to harassment, the tribunal had placed all its emphasis on whether it was reasonable for the conduct to have that effect. The statutory test, if you remember, says, quote, each of the following must be taken into account, unquote, in deciding whether there was harassment, and then goes on to refer, in addition to whether it was reasonable, it goes on to refer to the perception of B, the claimant in this case, and the other circumstances of the case, unquote. Once the tribunal, in effect, here had decided it was not reasonable for the conduct to have had the effect claimed by the claimant, they viewed that as a complete answer. Well, on the face of it, that seems pretty clear, doesn't it? The tribunal is, according to the statute, required to take into account the perception of the victim and the other circumstances of the case. However, the problem was a case called Pemberton and the Right Reverend Inwood, which is a Court of Appeal case, which expressly stated that if it was not reasonable for the conduct to be regarded as violating the claimant's dignity or creating an adverse environment for the claimant, quote, then it should not be found to have done so, unquote. In other words, the objective reasonableness test was a necessary hurdle the claimant had to get over before harassment could be found. Another way of putting it, Pemberton case says that the reasonable test, if I can put it that way in section 26(4), trumps everything else. If it was not reasonable for the conduct to have the alleged effect, then the perception of the victim and the other circumstances of the case can't, combined, overcome that point. It was argued by the claimant here that Pemberton was a gloss on the legislation, but the EAT simply did not accept this. It was clear that the law, before the 2010 Act, placed key significance on what I call the reasonableness question. Since there was no indication that Parliament intended to change the law in 2010, this, too, was strongly in favour of the Pemberton approach. On that basis, the tribunal's approach was correct, the EAT said, and that part of the appeal was rejected. Before I go on to the other part of the appeal, I think this part of the decision on harassment is an important point. If the tribunal of the EAT had gone the other way, it would have widened the circumstances in which someone could have been found guilty of harassment, even though it was not reasonable for the claimant to have taken the view that the effect of the conduct being challenged was harassment. So the case amounts to a pretty resounding endorsement of the long-standing approach, which is the court retains an overall objective test. If conduct is complained of as having a harassing effect, the court decides whether it was reasonable for it to be viewed that way. The claimant also appealed on the grounds of direct disability discrimination. It was found as a fact that he was suspended, and suspended is maybe the wrong term, but he was encouraged to take some time off, maybe is a more neutral way of putting it, because he was unable to write due to his hand pain. On that basis, the suspension had something to do with the claimant's disability. In rejecting the direct disability discrimination by the claimant, the tribunal had said that there were no facts to support it. Well, the claimant said the tribunal must be wrong to decide that. The tribunal was wrong to say my suspension for handwriting difficulties had nothing to do with my disability. It had everything to do with my disability. It was why I was disabled. But this too was rejected by the EAT. The EAT took the view the disability was not the difficulty in handwriting and hand pain. That was an adverse effect suffered by the individual. It is not the it was a description rather of the physical or mental difficulties he was suffering. It wasn't the impairment which gave rise to the problem. Here it was unclear precisely why the claimant has the difficulties he does with handwriting. The tribunal, according to the AT, drew a clear distinction between the adverse effect, the handwriting, and the underlying disability, cause unknown. He was suspended because of the handwriting difficulties. That was not a suspension because of his disability, and therefore this claim failed too. Now, the reason I want to mention this is it's a very narrow question as to whether or not someone is suspended because of a disability, as opposed to the impact of that disability on his abilities. As I mentioned at the start of this bit, the comparator when you're looking at a claim of direct disability discrimination, the comparator must have materially the same abilities as the claimant. It cannot be direct discrimination to suspend someone because of their abilities if a comparator would have been suspended because of their abilities in the same circumstances. So I think that's an important case too. The test for harassment is subject to the court's view as to whether or not it is reasonable for the claimant to view that as harassment, and the test for direct discrimination acknowledges a distinction between the disability itself, where direct discrimination would be prohibited, and the discrimination on the basis of the impact on the individual's abilities, which would not be direct discrimination. It would obviously be capable of being caught by other areas of the Equality Act, discrimination arising on the grounds of disability, indirect discrimination, etc. But for direct discrimination purposes, the test is clearly narrower. Next up, Antutsis and others, and DJ Houghton Catching Services Limited and others. I think this is a really important case on the liability of directors personally for breaches of contract by their company. If you've got a case where you're suing a company and the company may not have sufficient assets to pay the claim, then this case may be of considerable importance. Equally, if you're a director on the board of a company, then you need to know about this case because, potentially, personal liabilities for you could arise, although hopefully it would be most unusual. The underlying facts of this case are pretty horrible. Basically, the defendants, the corporate defendants, DJ Houghton Catching Services Limited, and the two main directors, Judge and Houghton, who are the individual defendants, were significantly exploiting their Lithuanian workforce. They made them work extremely long hours, paid them less than the statutory minimum provided by the relevant legislation, didn't pay sums which were due to them, the pay slips were a fiction, holidays were not paid for, etc., etc. Sounds a really gruesome operation. And the claimants in this case were seeking to sue the company and the directors on a summary judgment basis for breaches of express or implied term in their contracts of employment, looking at unpaid wages, unlawful deductions, and lack of holiday pay. The claimants qualified as agricultural workers, and so the necessary legislation on pay was to do with the Agricultural Wages Act 1948, but obviously the working time regulations applied as well, and the duties of the directors under the Companies Act 2006. Section 172 of the Companies Act, for example, provides that directors of a company have to act in a way which the director considers, in good faith, will be most likely to promote the success of the company, which involves taking into account company members, but the interests of company employees too, and their long-term interests. The bit I want to focus on is the personal liability for the directors of the company in this case. In general terms, if there is a tort, then the directors of the company are liable for a tort committed by the company at their direction. But here, what we're looking at is a breach of contract between the worker and the company. For 100 years or more, there's been a rule in place that said that if a director acting, firstly, bona fide, and secondly, within the scope of his authority, procured a breach of contract between his employer, the company, and a third person, the director did not become liable directly to the person whose contract had been broken. In other words, let's look at this as an example. Company A has a contract with Company B. The directors of Company A decide that Company A is going to break the contract with Company B. Company B can't sue the directors directly and in person if the directors are acting bona fide and within the scope of their authority. Now, this has been slightly developed in case law, so it applies only to protect persons in authority within corporate entities who genuinely and honestly endeavour to act in the company's best interests. That's the point I'm going to come back to. After extensive analysis in this case, the court confirmed its view that in looking at whether or not there was bona fide conduct, it's the officer's conduct and attention in relation to his duties towards the company, his company, that is important. So it's necessary for the individual to act bona fide. It's not necessary for the individual to act bona fide towards the third party. Here, the judge hearing the summary judgment application relied on Section 172 of the Companies Act. The duties that were broken were important duties. The Section 172 is an important duty on company directors to act in good faith to promote the success of the company and take into account its long-term interests. Although it did not necessarily follow that because the company's breaches here in relation to the workers, those are breaches of statute, that did not necessarily mean that the directors were also in breach of Section 172. It was a relevant factor that what was being broken was an express statutory law, in statute form. It was a relevant factor, but it didn't follow as night followed day, that merely because there was a breach of a statute, then the directors are personally liable. The court accepted the directors were acting within the scope of their authority, which you remember was one of the two things that needed to be shown if they were going to escape personal liability. However, the court said that they were acting clearly in breach of the Companies Act, and in particular the Section 172 and 174, which are similar terms. What the two directors were doing was not in the best interests of their own company or its employees, and in fact their actions had brought the company down. Neither director honestly believed that they were complying with the law and their treatment of the individuals. The directors were simply concerned to maximise the company's profits, which belonged to them solely. Therefore, they were not acting bona fide towards their own company when that company then was acting in breach of statute and regulation in relation to its workers. The court then looked at whether or not the directors induced the breach of contract between the company and the individuals, and the court had no doubt in finding that the individuals realised that what they were doing involved causing the company to break its contractual and statutory obligations towards the claimants. That was their intention because they profited from it. They had no honest belief, the court found, that what they were doing was in compliance with the law. On that basis, they were personally liable to the claimants for the breaches by their company. Now, I wanted to mention this case because it highlights the difference between tortious acts and inducing a breach of contract. Here, given the nature of the breaches, they were very clearly breaches, and the defendant directors benefited directly from those breaches and intended them to happen. I think it's entirely understandable that the directors were personally liable. Equally, I strongly suspect that the individual directors assumed that they could shelter behind the corporate structure, and so their personal income would have been protected. I think the question is, how far is this case going to go? Clearly here we've got a pretty ghastly case with individuals being ruthlessly exploited by all accounts for the benefit of directors. The reliance on Section 172 and 174 of the Companies Act in deciding whether or not individuals are acting bona fide towards the company is, I think, quite a significant step. Whilst many boards will have directors and officers liability policy, it's obviously far better that directors don't find themselves in the situation of being sued personally. And equally, I don't know this. I don't know whether a D&O policy would necessarily apply if individuals have been found to be acting in a way that is not bona fide towards the company. So, certainly a case to be aware of, although one would certainly hope as well it's an extreme case on its facts. Third and last case, Bosworth and Hurley and Arcadia Petroleum Limited and others. So this is a really interesting case on territorial jurisdiction in the European Court of Justice. The facts, which at this stage I think are all disputed, but for present purposes are relevant, are that the Arcadia Group, including Arcadia Petroleum Limited, are one of a number of companies trading as part of the Arcadia Group. Bosworth and Hurley are British nationals, but who are domiciled in Switzerland, and who were, at the relevant time, well, one of them was the CEO and the other was the CFO of the Arcadia Group. They were also directors of various Arcadia subsidiaries. In 2015, the Arcadia companies commenced proceedings against Bosworth and Hurley, alleging damages had been sustained as a result of fraudulent transactions. Those claims are contested. However, the question was where the claims should be decided. As I said, the individuals are domiciled in Switzerland, the claims were brought in England, and Bosworth and Hurley challenged the jurisdiction of the English court's ability to hear and determine the damages claim. They said that according to the Lugano Convention, they had to be sued in Switzerland. There was no dispute, they were domiciled in Switzerland. They were, they said, employees of Arcadia Petroleum. They had employment contracts. Under the Lugano Convention, very similar to the Brussels regulation, the employees are to be sued in the country in which they are domiciled in relation to claims arising against them, arising out of matters relating to their individual contracts of employment. So let's bear that in mind. The High Court and the Court of Appeal both accepted that the claims could proceed in the English courts, apart from some claims which were alleged to have occurred whilst Bosworth and Hurley were parties to their contracts of employment with Arcadia Petroleum. Case went up to the Supreme Court, which referred a variety of questions to the European Court. Amongst them, for example, was a question of what is the correct test when deciding whether a claim advanced by an employer against an employee is a matter relating to an individual contract of employment. What happens if other companies in the group sue the individual, but not the employer? The employer doesn't sue the individual. Is it still a matter under employment? Does a matter relate to an individual's contract of employment if the claim could have been formulated as a breach of contract claim, even if it's not actually formulated that way? However, they also referred to the European Court the question as to whether or not Bosworth and Hurley were employees within the test of the Lugano Convention, which, as I say, would almost certainly be the same test as the Brussels regulation. Pausing now, I should say there seems to have been no doubt that there was a contract of employment in place of Bosworth and Hurley. It doesn't seem to have been suggested this wasn't a genuine document. However, given that Bosworth and Hurley were running the companies and were not subordinate to anyone other than the shareholders, did the arrangements qualify as employment arrangements within the scope of the Lugano Convention? The court started and ended by answering the question as to whether or not they were employees for the purpose of the convention. The court categorised the question as being, could someone be an employee under the convention where that person is able to determine or does determine the terms of business for their contract and has control and autonomy over the day-to-day operation of the company's business and performance of his own duties? This is not a matter for the classification of national law, they said. The concept of employee has to be given an independent and consistent interpretation wherever the convention applies. Pausing there, that must be right. The essential feature of an employment relationship is that a person performs services for and under the direction of another person, for which he receives remuneration, according to the court. Therefore, there has to be a hierarchical relationship between the worker and the employer. The absence of an employment contract does not preclude an employment relationship, but conversely, here, the ability of the individuals to influence Arcadia, quote, was not negligible, unquote, and therefore there was no relationship of subordination. The fact that they were answerable to shareholders who could dismiss them was irrelevant. On that basis, the court decided they were not employees despite the fact they had contracts of employment. Therefore, the protection given under the Lugano Convention to employees, being sued in their own domiciled country, did not apply. So that's a bit of a turn up for the books, isn't it? In the UK, we're used to the fact that employment law applies to all employees irrespective of seniority status, etc. It's not unusual to find in mainland Europe, for example, that some of the most senior levels of director are excluded from employment protection rights. And certainly this assessment means that board directors in some companies, particularly where they are effectively running the show, are outside the scope of the convention and regulations when it comes to determining jurisdiction. In that context, I do wonder how literally the courts in the UK will interpret the fact that the Court of Justice said at one point that it was relevant that the ability of Bosworth and Hurley to influence Arcadia, quote, was not negligible, unquote. That sounds like a pretty low test to me, but I wonder if that was meant literally to be the test. which I personally doubt, whether it is simply another way of saying it was significant. But certainly if you're a director and you're being sued, or you're looking at suing directors of companies, a bit of a theme in this podcast, you need to know about this case because it may open up opportunities to sue individuals in jurisdictions more favourable than the one in which the individual is domiciled. So, there we go. Thank you very much for listening to this milestone 150th episode. Please do let me know if you approve the revamp. Oh, I mentioned a podcast recommendation for you. I would strongly recommend The Hurricane Tapes, which is on the BBC website. It combines, in a single podcast, two strands, both of interest to me. First of all, there's a definite musical link because it relates to the story of Reuben Hurricane Carter, about whom Bob Dylan wrote that fantastic song in the mid-70s whilst campaigning to have his conviction quashed. Equally, the alleged murders committed by Reuben Carter and a sidekick, his conviction for which was eventually quashed, make for a fascinating account. I've known the song for many, many years. The story is outstanding. The twists and turns in the podcast series will have you hanging on until the very end, because you really don't know which way it's going to go. So, the Hurricane Tapes are highly recommended. And as I said beforehand, it's got great theme music. Thanks very much for listening to this 150th episode.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.